All right, let's take a look at Contract Review 101. We're looking at contract review from an insurance perspective. So both for event-specific type contracts or university agreements or agreements that might occur with an independent contractor or something along those lines. Just as a reminder, please refer to your own organization's policies regarding contracts and contract review. In addition to this information, we're only going to discuss concerns from an insurance perspective and obviously can't touch on each of our clients' individual policies in this area. So this is just to supplement your existing organization's policies, not to substitute for them. Step one, of course, is to read the entire contract. This really is the most important part of the contract review process because there might be items in the contract that are separate from maybe the insurance subheading or anything like that. So you want to read the entire contract to see how it is going to impact you. When we're reviewing contracts, we read the entire contract and then go back and highlight any concerning or confusing language. And as Brett Michaels reminds us, thoroughly read all your contracts. I really mean thoroughly. Obviously, he probably has some experience in this arena. So step two is to highlight any of the following verbiage, and this would be a good slide here to print off and really just keep in your social planning handbook or risk management handbook, wherever that might be a good place that you can easily refer to it. But any of those items are going to be concerning and things that we're going to want to take a look at. So if we were reviewing the contract on our end, we would highlight anytime that any of this verbiage here occurred. Now, obviously, that language on the previous page probably doesn't make a lot of sense to most of you, as it shouldn't. So let's just take a little time out because insurance language can be very overwhelming and confusing, and we're going to try to dissect some of that language in the next few. Now let's take a look at some of these insurance-ease type verbiage that is concerning. An additional insured, when an entity or individual requires that you add them onto your policy as an additional insured, it means that they have coverage under your policy for defense costs if there is a lawsuit. Defense costs of a claim, we find they easily exceed the actual cost of the judgment. The additional insured is covered by the same provisions of your policy as you are, and they would be subject to any exclusions that do apply. But this is really free insurance for the entity or individual that's added onto your policy as an additional insured, and for that reason we don't like to add entities or individuals onto your policy as additional insureds, and we try to avoid it as often as possible. Hold harmless is another type of verbiage that is concerning. This basically is a provision in an agreement under which one or both parties agree not to hold the other party responsible for any loss, damage, or legal liability. So this basically precludes you from the opportunity to sue someone else for their actions. And so it's if there is a concern there, then you're on the hook if you have held the entity or the venue or the individual harmless for any loss or damages. This is concerning as well because often this language is any and all loss or damage, so it would apply whether or not there's insurance coverage for that claim, for that type of claim. And there are a few exclusions, not many, but a few under your organization's insurance policy. And so if there is hold harmless language, then you might be on the hook for a type of claim that would not be covered under insurance, which is obviously concerning. A few more concerning types of clauses would be the indemnity clauses. And basically, if you indemnify a party under a contract, then you're agreeing to compensate them for any harm or loss arising out of that contract, which is obviously concerning. And similarly to the hold harmless language, this applies whether or not there is insurance coverage for that type of claim, or for that exposure, I should say. Primary additional insured is basically kind of like super additional insured status, and this is very concerning, and your organization rarely approves of these types of contractual obligations because this requires that your policy or your organization's policy be primary and non-contributory. So that means that the entity or individual that is added as a primary additional insured, their insurance, or I'm sorry, your insurance, the organization's insurance, would have to be totally depleted before their insurance coverage would have to come into play, whether or not there's negligence. So that's obviously very concerning, and like I said, your organization rarely approves of those types of situations. Now, from our standpoint, as far as negligence goes, our opinion is that each entity should purchase insurance coverage to protect themselves from claims arising out of their own negligence. The clauses that we've discussed in the previous slides create an imbalance in terms of negligence because they force your organization to take on more liability for claims that may arise that are often outside the realm of your control. For this reason, we're leery when our clients sign contracts whenever the type of problematic verbiage is included that we've just discussed. That's why it's so important that you get us involved as your risk manager to see if we can minimize some of that language in those contracts or in some way negotiate with the venue or individual on your behalf. So now we're just going to take a look at a few claim scenarios that might give us a better picture of how this works in real life. So if you want to take a minute to read over this claim example here. So in this situation, it typically would be if the two of your guests at an event got in a fight and caused damage to the bar or to each other, and then there was a lawsuit that came about, which is what happened in this situation, then the liability would be split 50-50. You know, it was your guest that was there, but the bar has some liability too, especially if, you know, the bar could have overserved the guests, or there's a lot of different details that could be missing from this particular situation that would shed more light on who was actually at fault. But because the contract had additional insured verbiage and the sorority added the bar, on to their policy as an additional insured, automatically the sorority will be forced to take a larger share of the liability from the claim, whether or not, you know, like I said, there might have been more negligence on the part of the bar. That doesn't really matter once that additional insured language is in there. And really, you're leaving it up to a judge and jury to decide how the liability should be split up. But by having that additional insured verbiage in there, the sorority's policy will be expected to spend the money to defend the venue. So let's take a look at this next scenario. This one's a little bit different, dealing with an independent contractor. So take a minute to read over this scenario. So this type of verbiage is especially concerning when you're dealing with independent contractors, because one would think that they would be the expert and they should be responsible for, in this case, installing a chandelier. But when you have this confusing or concerning verbiage in these contracts, then that oftentimes puts more onerous on the part of the organization that really should fall on the independent contractor. So in this case, the House Corporation president did not properly review this contract. She should have had us review it as well, and we would have easily caught this primary additional insured verbiage, which basically precludes the sorority from going back against the independent contractor, in this case, to pay for the claims of the chapter members that were injured, in addition to the property damage that occurred from this improperly installed chandelier. So because the contract obligated the sorority to add the construction company onto the sorority's policy as a primary additional insured, the sorority is on the hook for all property damage and bodily injury caused by the faulty chandelier installation. So that would be quite expensive and something that really should have been covered from the construction company had the contract been structured properly or fairly in terms of the organization. So let's take a look at this next example that has to do with indemnity and hold harmless language. So in this situation, we have indemnity language, hold harmless language, and any and all language, which is really often the case. You will usually see contracts that have, this exact verbiage if you just sub out the Holiday Inn for whatever venue you're renting from. But the problem here is that really this claim where the Holiday Inn employee spilled a pitcher of water and didn't clean it up quickly enough, that should be the hotel's responsibility. They're the ones that have control over the employee. The sorority doesn't have control over that employee, and they should have to pay for this chapter member's medical bills. But because of the language in the contract, the sorority would be responsible and on the hook for that chapter member's medical bills as well as any pain and suffering that she might allege. And again, this contract is not allowing the sorority to be able to go against the Holiday Inn for compensation for something that really was their fault. So that's where that is concerning. So now we've gone over a few real-life examples. We've gone over kind of a glossary of terms of verbiage to be concerned about. Now, what we would prefer, and really you can skip to step 3 if you want to, but we're just trying to make you more knowledgeable members and volunteers about some various insurance language and what kinds of ramifications that language has, not only for the organization, but for you personally. It could be down the road that might help you in your own contract negotiations, either at a job or in your personal life or however that might work. But you are more than welcome to skip right ahead to step 3. Now, you definitely want to contact Ruth if you do see any of that concerning verbiage that we've gone over. But she also could just review the contract from the get-go for you. She is an expert at contract review, and she is also an expert and quite skilled at getting the venues or individuals to alter the verbiage so that it's more favorable for the sorority. Her contact information is listed there. And again, if you're unsure if there's any concerning verbiage, just send it right on to Ruth. She is more than happy to help you in those endeavors and really works diligently on your behalf to come up with the most fair contract possible. If the contract requires you to provide proof of insurance or a certificate of insurance, those terms are used interchangeably. Contact Ruth. The easiest and most efficient way to do that is via our website. We have a certificate request form at mjsorority.com, and you can actually attach the contract right there in that form, so it makes it really easy. Or you can contact Ruth directly. Her contact information was listed on the previous slide, and it's also available via these links here. This is the type of information that she is going to need if you contact her either via email or call her directly. Make sure that you have your organization's name and the Greek chapter name of your chapter, the date of the event, the type of the event, whether or not alcohol is being served, and if alcohol is being served, who is serving it, name and address of the venue and or individual requesting the certificate, your contact information and preferred contact method. So if you prefer to be contacted via email, fax, phone, we need that for you as who's requesting the certificate, as well as the information contact information for the individual to whom we'll be sending the certificate. If the venue is requesting additional insured status, we need to review the contract. We cannot provide that status without reviewing the contract. And Ruth reviews each request on a case-by-case basis in order to best serve our client's needs. We ask, if possible, they give her 2 weeks for any additional insured requests and as much time as possible really on any certificate request. She can always rush those if needed, but the more time she has, the better able she is to like I said, work out maybe a more favorable arrangement in whatever that contract looks like. Please don't hesitate to contact us with any questions. Again, the website is mjsorority.com. Our toll-free number is 888-442-7470. Thanks so much for listening, and we'll look forward to next time.